Jeffrey Epstein's name is etched into history as a symbol of secrets, power, and unanswered questions. Not just because of what he did, but because of what so many believe was covered up. For years, the public has demanded to know who else was involved, who else enabled him, who else might have been part of a network too powerful to touch. In a Senate hearing, Kash Patel was confronted with those exact questions. Senators pressed him again and again. Did Epstein traffic young women to others besides himself? And Patel's reply stopped the room cold. His words were simple. There is no credible information. According to the official files, Epstein trafficked to himself and no one else.
Ask you about the Epstein files. Have you seen the Epstein files?
I have not reviewed the entirety of it myself, but a good amount.
Okay. Would it be fair to say that Mr. Epstein trafficked young women, including, in some instances, minors, for sex to himself?
That was specifically the allegations in the 2018 indictment in the Southern District of New York.
Okay. Who else did he traffic these young women to?
In terms of what the investigation, again, going back to 2008, Mr. Acosta, who limited the investigation and limited the search warrants and limited the parameters of the investigation, the only thing we are able to speak to publicly, because he was given a non-prosecution agreement by Mr. Acosta, is that first time period from, I believe, don't quote me on this, 97 to 2001-ish. And then when the Trump administration courageously reopened it.
Excuse me for interrupting, but I'm going to run out of time. You've seen most of the files. Who, if anyone, did Epstein traffic these young women to besides himself?
Himself. There is no credible information. None. If there were, I would bring the case yesterday that he trafficked to other individuals. And the information we have, again, is limited.
So the answer is no one?
For the information that we have.
In the files?
In the case file.
Okay. Now, President Trump has deferred to the FBI and the Department of Justice with respect to the Epstein records. He says it is your call about releasing them. And I understand that the department and the agency have decided to release them in cooperation with the House committee. Is that correct?
Yes, sir.
So you're releasing them a little bit at a time. Is that correct?
We're releasing as much as we can, but we are limited by 3 different court orders, and the department went back to each of those judges to waive those court orders or have them lifted, and each of those judges declined.
Will you release all of them, or at least as many as you can?
We will release everything we are legally permitted to do so. We are continuing to work with the House on the subpoena request. We have substantially complied with it, but we will continue to release whatever we are legally permitted to do so.
Okay. I strongly encourage you to do that, Cash. This issue's not going to go away. And I think the central question for the American people is this. They know that Epstein trafficked young women for sex to himself. They want to know who, if anyone else, he trafficked these young women to. And that's a very fair question. I want to know that answer. And I think you're going to have to do more to satisfy the American people's understandable curiosity in that regard.
Mr. Chairman, may I just respond to that? I agree, Senator. And what we have done, and just to remind folks, the Epstein case files existed in the 2 prior administrations, in the Obama administration and the Biden administration. And they didn't release anything. And there was President Trump in the first administration that renewed charges against Mr. Epstein. And I know it's a little complicated to understand, but what exists in the Epstein case files was a direct result of the limited search warrants from 2006 and 7, which hamstrung future investigations because of the non-prosecution agreement. And multiple administrations had the opportunity to look at the entirety of that case file and recommend prosecutions against anyone that was trafficked under Mr. Epstein and anyone that participated in that trafficking. And the only person to bring charges was the prior administration against Mr. Epstein. Now, I am not saying that others were not trafficked and others were not involved. What I am telling you is that based on the information we have, and we have continuously and publicly asked for the public to come forward with more information. If there is, we'll look at it. But based on credible information, we have released all credible information, and the information that the Department of Justice and the FBI never releases is information on investigations that are not credible. And we don't release the names of victims who weren't credible, but in the same time, we don't release the names of victims who were credible. And so the information, that's by law. And so the information we are releasing now is historic, and it is also to the maximum capacity that the law allows. And I know that's not going to satisfy many, many, many people. But if they wanted it done right, then the investigation from its origination should have been done right, and he should not have been given a get-out-of-jail-free card to do jail on the weekends for 12 hours a day, and he should have been investigated fully for the entirety of his crime and criminal enterprise, not just from 1997 to 2001.
Senator Blumenthal.
Thank you, Mr. Patel.
But does that answer really end the mystery? Or does it raise even bigger ones? Because if Epstein's case was boxed in by narrow investigations, sealed records, and legal deals struck decades ago, then maybe the silence isn't proof of innocence. Maybe it's proof of how carefully the truth was buried. And that's why, when Patel spoke, disbelief hung in the air. Because the American people don't just want legal precision. They want names. They want accountability. They want the truth. When Kash Patel sat before the Senate, the room wasn't waiting for long speeches or legal jargon. Everyone knew the one question that had to be asked. If Jeffrey Epstein was a trafficker, then who else did he traffic victims to? Senator after senator pressed Patel with the same words millions of Americans have repeated in conversations, on social media, and in headlines for years. Was Epstein acting alone? Or was he part of something bigger, something darker? Patel's answer was as blunt as it was unsettling. Himself, he said, no hesitation, no qualifiers. Just a firm denial that the case files contain credible evidence tying Epstein's victims to anyone else. For a moment, the hearing fell heavy with silence. Because the weight of that statement wasn't just about one man's crimes. It was about collapsing an entire theory, about powerful names, secret deals, and whispered networks, into nothing more than Epstein himself. And yet, the simplicity of that answer didn't ease suspicions. If anything, it deepened them. Because when questions linger this long, when files remain sealed and investigations remain limited, silence begins to sound less like truth and more like protection. And that left the senators and the public unsatisfied to understand why Kash Patel's answer felt so hollow. You have to go back nearly 2 decades to a decision that shaped everything that followed. In 2006 and 2007, prosecutors had Epstein in their sights. Investigators knew enough to uncover disturbing patterns, but instead of opening every door, the case was quietly boxed in. Alex Acosta, then the U.S. attorney, struck what's now infamous as a non-prosecution agreement. That deal was extraordinary. It didn't just shield Epstein from the harshest penalties, it clipped the wings of investigators themselves. Search warrants were narrowly written. The time frame for evidence was restricted. Entire avenues of inquiry were shut down before they could even be explored. In effect, the case was walled off, and many of the questions the public is still asking today were sealed away with it. The result? A scandal that was never fully mapped. A network that may have stretched far beyond Epstein himself was left unexamined, undocumented, and unproven. The deal of a lifetime didn't just protect one man. It limited the entire scope of justice. And that's why, years later, hearings still circle the same unresolved questions. Because when a case is buried at its roots, the truth can never grow to the surface. After the 2007 non-prosecution agreement, the Epstein scandal could have been revisited. Multiple administrations had the authority to reopen investigations, broaden the search, and finally pursue accountability. But they didn't. Years went by, and the files sat mostly untouched, quietly collecting dust while rumors about Epstein's connections only grew louder. According to Kash Patel's testimony, nothing prevented later leaders from digging deeper. The limitations of the original deal were real, but not permanent. New subpoenas could have been issued. Wider warrants could have been pursued. Yet the choice was made, again and again, to leave the case confined to the narrow frame that had been set years earlier. This inaction wasn't just a missed opportunity, it was a message. For survivors who waited for justice, it signaled indifference. For the public, it suggested something far worse, that powerful interests were being shielded. And every year that passed without movement added to the suspicion that the silence was intentional. So when Patel insists that only Epstein appears in the files, critics hear not clarity but confirmation of failure. Because the truth is simple. If earlier administrations had acted, the record might tell a very different story. Instead, the silence left space for distrust to grow. Kash Patel's testimony rested on a phrase that sounded definitive but carried layers of ambiguity. No credible information. On its face, that sounds like the case is closed, that Epstein trafficked victims only to himself and no one else. But in the language of law enforcement, those words don't mean nothing happened. They mean nothing can be proven, at least not with the evidence currently in the file. And that's where frustration boils over. Because the files Patel refers to are the product of a case that was already weakened years earlier. If investigators were boxed in from the start, if search warrants were narrow and evidence was suppressed by legal agreements, then of course the official record looks incomplete. To the public, no credible information sounds like denial. To prosecutors, it means something far less final. We don't have enough to bring charges. That gap in meaning explains why Patel's answer felt like a door slammed shut, even though it may have simply been a cautious technical statement. Still, the impact is the same. Millions are left with more questions than answers, and the official record feels less like clarity and more like a carefully constructed silence. If there's one thing that fuels suspicion more than unanswered questions, it's secrecy. And in the case of Jeffrey Epstein, secrecy has been the constant shadow. Kash Patel admitted that the release of records isn't complete, not because the FBI refuses, but because court orders block large portions from ever seeing the light of day. Judges have denied motions to lift restrictions, meaning the files the public sees are only fragments of the whole story. This trickle of information has done little to calm outrage. Instead, it feeds the perception that something, or someone, is being protected. Each new partial release only sharpens curiosity about what's still hidden. Why are names redacted? Why are certain documents sealed? Why does it feel like the truth is locked in a vault the public isn't allowed to open? Patel insists the FBI is releasing everything it legally can. But the more that's withheld, the stronger the sense that power shields power. For many Americans, it's not about the technicalities of court orders. It's about the possibility that justice is being managed rather than delivered. And every locked page deepens the belief that the full truth is still out of reach. The Epstein hearings revealed more than just the limits of an investigation. They exposed the uneasy clash between law and politics. On one side, senators demanded straight answers, pressing Kash Patel to give the public the clarity it has craved for years. On the other side, Patel held firm to legal caution, careful not to step beyond what the files officially contain or what the courts allow him to release. This tension created a spectacle that was as frustrating as it was telling. The lawmakers wanted accountability, names, and an explanation for decades of secrecy. Patel, bound by the technicalities of law, could only offer a narrow response. Epstein himself and no one else. To the public, that sounds evasive. To Patel, it was the only legally defensible answer. But the result was the same: frustration. Because hearings are not just legal proceedings, they are also public theater. And when the American people see officials dodging their deepest questions, the impression left behind is that the system is protecting itself. In that moment, it wasn't just Epstein's crimes under scrutiny. It was the justice system itself, standing exposed as either too weak or too unwilling to pull back the curtain fully. For most Americans, the Epstein scandal has never just been about one man. It's about the world around him, the enablers, the protectors, the powerful figures who may have turned a blind eye or even benefited from his crimes. That's why Patel's testimony, however precise in legal terms, rings hollow in the public imagination. People don't just want to hear that Epstein trafficked to himself. They want to know who else was there, who else allowed it to happen, and why the truth has been so carefully fenced off. This hunger for answers is about more than justice for victims, though that should always come first. It's also about trust. When the system says, no credible information, it feels like another way of saying, you don't get to know. That widening gap between what officials can say and what the public demands to hear is exactly where suspicion thrives. Americans want moral clarity, not just legal precision. They want a full accounting of how Epstein operated in plain sight for years and who helped keep his empire alive. And until those names are spoken, until those files are unsealed, every careful statement will only sound like another layer of protection for the powerful. In the end, the tragedy of the Epstein saga isn't just the crimes themselves. It's the feeling that accountability was never truly pursued, that decisions made years ago carved cracks so deep the truth may never fully surface. Kash Patel's testimony distilled that frustration into a single blunt phrase: Epstein trafficked to himself and no one else. On paper, it was an answer. In reality, it sounded like a verdict delivered with blinders on. Because the public doesn't just want a technical explanation. They want the full scope of a scandal that has haunted headlines for decades. They want to know how Epstein built his empire, who stood beside him, and who helped him stay untouchable for so long. Every sealed file, every redacted name, every cautious legal phrase feels like another reminder that the system may be protecting itself rather than the people it serves. And that's why this story refuses to die. It lingers, not because of conspiracy theories alone, but because the silence of institutions leaves space for them to grow. Until the full truth is revealed, suspicion will remain the lasting legacy of Epstein's crimes. The question is simple: will the powerful ever allow that silence to break?